Hello everyone, welcome to another video of this RFBT series. My name is Mark and today we are going to talk about the anti-bouncing check law. With that said, let's begin. The anti-bouncing check law, otherwise known as Batas Pambansa bilang 22 or BP 22, was enacted into law in the years 1979 to penalize issuers of worthless checks that could not be punished for estafa under the revised penal code. Now, for those of you who are too lazy to watch the entire video, here is a quick summary of BP 22. BP 22 penalizes a person who issues a worthless check on account or for value regardless of the reason of issuance. Because this law does not consider the presence of deceit or fraud in the issuance of worthless checks, good faith is not a valid defense. Before we continue, we have to answer this important question. What exactly is a check? According to Section 185 of the Negotiable Instruments Law, a check is a bill of exchange drawn on a bank payable on demand. To clarify the definition of a check, Judge Vilches in her book defined a check as a written request or order by a depositor called the drawer to a bank called the drawee to pay on encashment a person called the payee a certain sum of money. In short, the depositor who issues the check orders the bank to pay the lawful holder of the check. The amount paid is then deducted from the depositor's checking account in the bank. So here we have several examples of checks from different banks. The drawer or issuer of the check is usually found at the top portion of the check indicated by the account name. The drawee, on the other hand, is the bank to which the check pertains to. Remember that the drawee is the one who will pay the amount stated on the check. The payee, on the other hand, is the one who will receive the said amount, and the payee right here is Roy Ang. So please take note the parties to a check, which are the drawer, the drawee, and the payee. What people don't realize is that you only have a limited time to cash the check, otherwise it will become stale. So the question now is, when do checks become stale? According to Section 186 of the Negotiable Instruments Law, a check must be presented for payment within a reasonable time after its issue, or the drawer will be discharged from liability thereon to the extent of the loss caused by the delay. Under current banking practices, a check becomes stale 6 months after the date appearing on the check. When a check becomes stale, it cannot anymore be cashed with the drawee bank. The proper remedy here is to request the drawer of the check to issue a new one. Because we are talking about the anti-bouncing check law, the next question would be, are stale checks bouncing checks? The answer to that is no. Stale checks are not bouncing checks. Stale checks cannot be cashed due to the payee's negligence in not presenting it to the bank for encashment within a reasonable time, herein 6 months. Bouncing checks cannot be cashed because the drawer's account to be charged has insufficient funds or is closed and said drawer had knowledge of such insufficiency. So we talked about checks and we talked about stale checks. Now we have to talk about bouncing checks. So what is a bouncing check? A bouncing check is a check that bounces from the drawee bank and back to the drawer of said check. A bouncing check is oftentimes referred to as a rubber check because rubber has properties that allows it to bounce. According to Judge Vilches, a check bounces either because there is not enough money or credit in a bank to cover its amount, as in DAIF, drawn against insufficient funds check, and NSF, non-sufficient funds check. A check bounces also for the simple reason that the same was drawn against a closed account. Now, what crimes can you commit by issuing a bouncing or worthless check? The first one is violation of Section 1 of BP 22 and Estafa under Article 315, Paragraph 2, Subsection D of the Revised Penal Code. Now do take note that each of these crimes has their own elements that you need to satisfy. If you cannot satisfy all of the elements of the said crime, then you cannot convict the drawer who issued the said bouncing or worthless check. So how do you violate BP22? According to Section 1, there are two ways for you to violate it. The first is by making or drawing and issuing any check to apply on account or for value, knowing at the time of issue that one does not have sufficient funds in or credit with the drawee bank for the payment of such check in full upon its presentment, and said check is subsequently dishonored by the drawee bank for insufficiency of funds or credit, or would have been dishonored for the same reason had not the drawer, without any valid reason, ordered the bank to stop payment. The second is by making or drawing and issuing a check while having sufficient funds in or credit with the drawee bank, but failing to keep sufficient funds or to maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing in the check, for which reason it is dishonored by the drawee bank. So to summarize Section 1, you could violate BP22 by performing any of the following: by making or drawing and issuing a check, knowing that you have insufficient funds and said check was dishonored, or by making or drawing and issuing a check while having sufficient funds but failing to maintain said funds within 90 days from the date of the check and said check was dishonored. So we mentioned earlier that we have to satisfy all of the elements of the crime in order to convict the offender of committing the said crime. According to Attorney Boado in her book, the following are the elements in violating BP22. The first is making or drawing and issuing a check to apply on account or for value. The second is knowledge of the maker, drawer, or issuer that at the time of issue he does not have sufficient funds in or credit with the drawee bank for the payment of the check in full upon its presentment. The third and last is subsequent dishonor of the check by the drawee bank for insufficiency of funds or credit, or dishonor of the check for the same reason had not the drawer, without any valid cause, ordered the bank to stop payment. Now do take note that the elements enumerated here pertains to the first way of violating BP22. As to the second way of violating BP22, the maker or drawer or issuer of the check must have knowledge of insufficiency of funds with the drawee bank at any time within the 90-day period from the date appearing on the check. The third element of violating BP22 talks about dishonor. Dishonor is the act of the bank of refusing to accept the check and paying the stated amount. Now, a notice of dishonor is a notice given to the drawer informing him or her that the check he or she issued was dishonored by the drawee bank, the reason behind such dishonor, and that he or she has 5 days to make good on the check. Take note that a notice of dishonor must be made in writing. An oral notice of dishonor is not enough. A notice of dishonor can be made by the drawee bank or the payee or both. A notice of dishonor must be received by the drawer, and the absence of a written notice of dishonor received by the drawer is fatal to the case of violation of BP22 against said drawer. Now let's go over a few scenarios. One day, Jason decided to write a check payable to cash in the amount of 10,000 pesos and left the same on his desk. A while later, Kaiser saw the check on Jason's table and took it. Since the check was payable to cash, the holder of such check can cash the same. Since the check is now in Kaiser's possession, he went to the bank to have it cashed. The bank dishonors the check because Jason's bank account only contained 5,763 pesos and 52 centavos. The bank also notified Jason in writing of the dishonor. 1 month after Jason's receipt of the notice of dishonor, Kaiser filed a criminal case of violating BP22 against Jason. Assuming that the check was not prostated, Will Jason be criminally liable for violating BP 22? So what do you think is the answer to the question? The answer is no, Jason will not be criminally liable for violating BP 22. In order to be liable, he should have first made or drawn and issued a worthless check to apply on account or for value. In this scenario, while Jason made or drew a check, he never issued the same to anyone or for any transaction on account or for value. He merely left it on his desk. So even if he has insufficient funds to satisfy this check, he will not be criminally liable for violating BP 22. Now let's go to our second scenario. Suppose Jason gave the check to Kaiser for the latter to keep it safe until the former will use it, and Kaiser instead tried to cash the check. Assuming that the check was not a post-dated check and the proper notice of dishonor was given to Jason, will Jason be criminally liable for violating BP 22 if Kaiser files a criminal case against him 1 month after Jason's receipt of the notice of dishonor? So what do you think is the answer to number 2? The answer is no, Jason will still not be criminally liable for violating BP 22. In order to be liable, he should have first made or drawn and issued a worthless check to apply on account or for value. In this scenario, while Jason issued the check to Kaiser, he never issued the same on account or for value. He merely gave it to Kaiser for safekeeping. Alright, here is the third scenario. Suppose Jason gave the check to Kaiser in payment for the former's debt of 10,000 pesos to the latter. Assuming that the check was not a post-dated check and that proper notice of dishonor was given to Jason, will Jason be criminally liable for violating BP 22 if Kaiser files a criminal case against him 1 month after Jason's receipt of the notice of dishonor? What do you think will be the answer to this question? The answer is yes, Jason will be criminally liable for violating BP 22. Finally, in order to be liable, he should have first made or drawn and issued a worthless check to apply on account or for value. In this scenario, Jason issued a check to Kaiser on account of the former's debt to the latter. Since the check was issued on account or for value, Jason is criminally liable for violating BP 22 by issuing a worthless check. Now you might be wondering, in the previously given scenarios, I never mentioned whether or not Jason had knowledge that his account had insufficient funds to cash the check. How come I managed to come to a conclusion? The answer is, in the said scenarios, Jason is presumed to have knowledge of insufficient funds. This will be discussed next. But before we continue, it's time to ask the question of the day. What kind of superpower or special ability would you like to have? Ever since I was little, I always dreamt of having the power to generate and control electricity. Now, it's not really because of practical uses like having unlimited electric power in the household, but more so because it's cool to describe electric-based attacks when writing my stories. So what about you? What kind of superpower or special ability would you like to have? Now going back to our topic of knowledge, we have the concept of presumption of knowledge. Section 2 of the anti-bouncing check law states that the making, drawing, and issuance of a check, payment of which is refused by the drawee because of insufficient funds in or credit with such bank when presented within 90 days from the date of the check, shall be prima facie evidence of knowledge of such insufficiency of funds or credit, unless such maker or drawer pays the holder thereof the amount due thereon, or makes arrangements for payment in full by the drawee of such check within 5 banking days after receiving notice that such check has not been paid by the drawee. Breaking down the provision of Section 2, we have the remedy of the drawer when he receives a notice of dishonor. Under Section 2 of the Anti-Bouncing Check Law, the maker or drawer is given 5 banking days to settle his account by performing either of the following: by paying the payee or holder the amount due in the check, or by depositing sufficient funds to his account with the drawee bank, or making arrangements for payment in full by said drawee bank. If the maker or drawer fails to settle his account within 5 banking days, he shall be presumed to have knowledge of the insufficiency of funds, provided that the payee or holder presented the check for payment with the drawee bank within 90 days from the date appearing in the said check. Take note that when a check is presented to the bank for payment beyond 90 days after the date on the check, presumption of knowledge will not apply anymore. You now have the burden of proving that the drawer indeed had knowledge of insufficiency of said funds. Case in point, deposit or cash your checks immediately or as soon as possible. Now let's go over to the duty of the drawee bank. According to Section 3 of the Anti-Bouncing Check Law, it shall be the duty of the drawee of any check, when refusing to pay the same to the holder thereof upon presentment, to cause to be written, printed, or stamped in plain language thereon, or attached thereto, the reason for the drawee's dishonor or refusal to pay the same, provided that where there are no sufficient funds in or credit with such drawee bank, such fact shall always be explicitly stated in the notice of dishonor or refusal. Now we have mentioned the word credit several times now. But what exactly is credit? According to Section 4 of the Anti-Bouncing Check Law, the word credit shall be construed to mean an arrangement or understanding with the bank for the payment of such check. Let us refresh ourselves on the fact that when we open an account with the bank, we are basically lending them money. Thus, we are the creditors and the bank are our debtors. The credit herein is the outstanding amount we lent to the bank, which they have to pay upon demand. What are the penalties for violating BP 22? Imprisonment of not less than 30 days but not more than 1 year, or a fine of not less than but not more than double the amount of the check but shall in no case exceed 200,000 pesos, or both imprisonment and fine. Now, if you were the judge, what penalty will you impose upon a person convicted of violating BP 22? Is it imprisonment, fine, or both? According to Supreme Court Administrative Circular Number 12, Series of 2000, as much as possible, under applicable circumstances, only the fine shall be imposed as penalty. Take note, however, that the same circular did not remove the penalty of imprisonment. It only urged judges to impose the lesser penalty to best serve the ends of criminal justice. Surely enough, if it can be shown that the worthless check was issued for fraudulent purposes, there is no stopping the judge from giving out the penalty of imprisonment. Now do take note that each issuance of a useless check shall count as one violation of BP 22. Hence, it is possible to exceed the 1-year maximum imprisonment or the 200,000 pesos maximum fine if you have issued several useless checks, subject to the penalty limitations set out by law. So if someone files a case of violation of BP 22 against you, what defenses can you raise? Number 1, you have not received a written notice of dishonor. Number 2, there is prescription. Prescription is the termination of the right or power to prosecute or punish the offender after the lapse of a definite period from the commission of the crime or discovery thereof. In BP 22 cases, the prescription sets after 4 years after expiration of the 5 banking days from notice of dishonor. Number 3, duplicity of offenses. A single information charges more than one offense. This is because, as a rule, each information filed in court must contain only one offense. Thus, if you issued 10 worthless checks, 10 informations for violating BP 22 should be filed with the court. Fourth, forgery. A check is forged when the signature appearing on the check was made without the authority of the person whose signature appears on it. Fifth, lack of necessary signatures to the check. The check is not considered bounced if the bank refused to pay on the check by reason of lack of signature of the drawer. Sixth, due payment or performance of the obligation. Making good on the obligation will bar conviction. Seventh, failure to present the check for payment within 90 days from the date appearing on the check. Eighth, dishonor with a mere stamp in the check, stop payment. Banks are required to state the reason of the stop payment order. If the reason for the stop payment order was due to insufficient funds, the drawer of the check may be held liable for violating BP 22. Now here is an interesting question. Are foreign checks covered by BP 22? According to Judge Vilches, citing De Villa v. Court of Appeals, a foreign check is a check drawn against a foreign bank. Normally, a special law like BP 22 will have no exterritorial application. All the same, in the case of Kev v. People and the IAC Supra, it was decided that a bounced foreign check falls within the criminal contemplation of BP 22. Foreign checks, provided either they are drawn and issued in the Philippines, though payable outside, are within the coverage of the law. Now, we have previously mentioned that another crime that you can commit when you issue a worthless check is estafa. Specifically, estafa under Article 315, Paragraph 2, Subsection D of the Revised Penal Code. Estafa under the said article is committed by postdating a check or issuing a check in payment of an obligation when the amount in the offender's bank account is not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from the receipt of notice from the bank and or the payee or holder that said check has been dishonored for lack or insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act. An important thing to note is that the worthless check must be issued by the drawer simultaneous with or prior to the performance of the obligation of the payee. This presupposes that the payee performs his obligation to the drawer under assumption that the issued check is not worthless. Thus, what is being punished is the deceit caused by the drawer in issuing a worthless check. If the check was issued to pay the drawer's pre-existing obligation to the payee, there is no estafa committed. Now let's go to another scenario. Tony engaged the IT services of Christina. They both agreed that Tony will pay 7,500 pesos to Christina after the latter finishes rendering her services. After finishing her obligation to Tony, she demanded payment. Tony explained that due to lack of funds in her possession, she will pay Christina next week. 1 week later, instead of paying, Tony issued to Christina a check worth 7,500 pesos. When Christina tried to cash it, the bank dishonors the check due to insufficient balance in Tony's account. If notice of dishonor was properly given and Tony was given time to make good on the check to no avail, may she now be liable with estafa or violation of BP 22? Here is the answer to the question. Tony may not be liable for estafa under the Revised Penal Code. The Revised Penal Code requires that the issuance of the check must be simultaneous with or prior to the performance of the obligation of the payee. Here, Christina performed her obligation first, prior to being paid. Hence, Tony's issuance of the check to Christina was to pay a pre-existing obligation she has with the latter. However, Tony may be held liable under BP 22, whether she issues the check simultaneous with or prior to the performance of the obligation of the payee or to pay off her pre-existing obligation with Christina is not essential. BP 22 makes the offender liable for merely issuing a worthless check. so long as all the elements of the violation are present. Let's go to our very last question. Can a person be held liable for violation of BP 22 and Estafa at the same time? The answer is yes. Section 5 of the Anti-Bouncing Check Law states that prosecution under the said law shall be without prejudice to any liability for violation of any provision of the revised penal code. And so that ends our lecture for the anti-bouncing check law. If you want to check out my sources, they are listed right here. So I hope you learned a thing or two about BP22. Special thanks to Charles Novo for the digital art. Thank you all for listening. Thanks for watching. I hope to see you again in the next video. But for now, this is goodbye.